Companies Act, Section 273, Powers of the Tribunal in a Petition for Winding Up. Section 273 of the Companies Act, 2013 lays down the powers vested in the National Company Law Tribunal, NCLT, when it receives a petition for winding up of a company under Section 272. The provision empowers the tribunal to take a broad range of actions, based on its evaluation of the petition and surrounding facts. It also provides procedural safeguards, timelines, and conditions to ensure fairness in adjudication. This section ensures that the tribunal's decisions are informed, balanced, and made in the interest of justice, company stakeholders, and the broader public interest. Subsection 1. Discretionary powers of the tribunal on receipt of a petition. Upon receiving a petition for the winding up of a company, the tribunal is authorized to take any of the following actions. A. Dismiss the petition. The tribunal may reject the petition outright, either with costs, requiring the petitioner to bear expenses, or without costs, if it deems the petition unjustified or lacking sufficient merit. B. Pass an interim order. The tribunal is empowered to issue any interim or temporary order it considers appropriate. This may include directions to preserve the status quo, protect company assets, or maintain transparency in operations until a final decision is made. C. Appoint a provisional liquidator. The tribunal may appoint a provisional liquidator for the company, who shall temporarily take control of the company's affairs until a final order for winding up is made. This measure helps prevent asset stripping or mismanagement during the pendency of the proceedings. However, before appointing a provisional liquidator, the tribunal must notify the company of the proposed action, and give it a reasonable opportunity to present its case or objections. This requirement can only be bypassed if the tribunal records special reasons in writing for dispensing with the notice, ensuring exceptional circumstances justify the deviation from standard procedure. D. Make an order for winding up. The tribunal may pass a final order to wind up the company, thereby initiating the formal process of liquidation. This may be done with or without costs, depending on the tribunal's discretion and the nature of the petition. E. Pass any other order. The tribunal has the residual authority to make any other order that it considers appropriate in the circumstances. This wide discretion allows the tribunal to tailor its orders to suit the specific facts and requirements of each case. Timelines and procedural safeguards. Time limit for order. As per the first proviso to subsection 1, the tribunal is required to dispose of the petition within 90 days from the date of its presentation. This ensures timely resolution of winding up petitions and prevents prolonged uncertainty for the company, its creditors, and other stakeholders. Protection of companies against arbitrary appointment of provisional liquidators. The second proviso mandates that no provisional liquidator may be appointed without notice to the company, unless the tribunal finds and records special reasons justifying such an exception. This ensures that companies have a fair chance to defend themselves before such a significant action is taken. Assets not a barrier to winding up. Under the third proviso, the tribunal cannot refuse to wind up a company solely on the grounds that the company's assets are already fully or overly mortgaged, or the company has no assets at all. This means that lack of free or unencumbered assets is not a sufficient reason to reject a winding up petition, especially when other justifying grounds exist under Section 271. Subsection 2. Tribunal's discretion in just and equitable cases. In cases where the winding up petition is filed under Clause E of Section 271, that is, on the ground that it is just and equitable to wind up the company, the tribunal retains further discretionary authority. If, after examining the matter, the tribunal is of the view that an alternative remedy exists, and the petitioner is acting unreasonably by seeking the company's winding up instead of availing the alternative course, then the tribunal may refuse to pass a winding up order. This provision discourages the misuse of winding up petitions as a tactic for resolving shareholder disputes or internal disagreements when other remedies, such as oppression and mismanagement proceedings under Sections 241 and 242, are more appropriate. For more details, contact us.